Hi, I'm Professor Mark Grabowski, and in this short video, I want to walk you through how media laws are made in the United States. Now, I know what you're thinking. Laws? Sounds boring. But hang on. If you've ever posted a meme, streamed music, or wondered if it's legal for a politician to block someone on social media, this stuff affects you. In the United States, there are 5 main ways media laws are created: constitutional law, statutory law, administrative law, executive actions, and judicial decisions. Let's break each down in plain English. First, constitutional law. This comes from the U.S. Constitution, of course, especially the First Amendment, which protects freedom of speech and freedom of the press. It's the foundation of most media law. But here's the catch. Constitutional law is often pretty broad. For example, what exactly does freedom of the press mean in the digital age? That's where the next sources of law come in. The second source of law is statutory law. These are specific laws passed by elected officials, like Congress, state legislatures, and city councils. For instance, Congress passed the Freedom of Information Act, which gives journalists access to government records. States pass laws on things like libel, privacy, and open meetings for the school board, while local governments can regulate things like where newspapers place racks or where billboards can go. One way to think about it, constitutional law sets the big picture rights. Statutory law fills in the details. The third source of law is administrative law. Once a law is passed, someone has to figure out how to make it work. That's where administrative agencies come in. They create rules and enforce them. Some key agencies that impact media include the Federal Communications Commission, or the FCC, which regulates broadcast media and internet service providers. The Federal Trade Commission, or FTC, monitors advertising and protects consumers from deceptive marketing. The Federal Election Commission oversees political ads. The U.S. Patent and Trademark Office handles intellectual property, like logos and inventions. And the Department of Justice enforces criminal laws, including those related to media. For example, the DOJ might prosecute someone who runs a site that illegally distributes copyrighted movies or music. That's criminal copyright infringement. Or the DOJ might charge someone for revenge porn, which is when someone shares private explicit images without the person's consent. In many states, that's now a crime. Of course, these are only a handful of the many government agencies. A fourth source of law is executive action. Presidents, governors, and mayors can issue executive orders, but these usually don't have a huge direct impact on media law. Still, the president can influence media law indirectly by appointing judges or choosing who runs powerful agencies like the FCC. Those decisions can shape how laws are interpreted and enforced. Finally, there are the courts. When someone sues a journalist for libel, or a new law is challenged as unconstitutional, judges make decisions that shape media law. This is called case law, or sometimes judge-made law. Over time, these court rulings define what our rights actually mean in practice. Now that all sounds pretty straightforward, right? Well, not quite. Creating new laws, especially in the digital age, is really hard. Here's why. Technology moves fast. Laws take time to catch up. Politics are polarized. Gridlock in Congress is common. Many lawmakers don't understand technology well enough to regulate it effectively. And a lot of Americans don't understand how laws are made or how the government works, which can lead to government overreach or rights being violated. That's why courses like this one matter. Understanding how media law works helps you protect yourself and maybe even change the system. Well, this has been Professor Grabowski. Thanks for watching.